Good morning, Signature Real Estate Group. Happy Tuesday. Welcome. Today's meeting is going to be our legislative update, and I am on the corner of my eye. I can actually see Shelly jumping up for joy right now because she's super excited to get started. So Shelly, I'm going to pass this on to you to do our mortgage moment.
Good morning, everyone. Happy Tuesday. So I want to share a couple of things. Number one, there's been a lot of questions provided to us or asked of us about the appraisal waivers. And I just want to clarify with everyone. So we can issue an appraisal waiver on conventional financing only. So if your buyer is doing FHA or VA, unfortunately we do have to go through the process of getting an appraisal ordered. As far as conventional financing is concerned, the way that we determine whether an appraisal waiver is required is we actually have to run the borrower through using the actual address, and it will fire off an appraisal, what they call a PIW, which is a property inspection waiver. So it's not just an automatic thing that we can set on conventional financing, but conventional loans are the only loans that can fire off an appraisal waiver. So if you have any questions, reach out to one of your Prosperity Lending loan officers. Something else I also want to share with you is this bid over ask tool, and you'll see here to my right is the bid over ask co-branded flyer that we have. This has been very helpful in showcasing what it would look like for a client as the appreciation, which has been determined by a forecast that we've had on our through our site through MBS Highway. It'll actually showcase here, this example is $10,000 over appraised value. It determines about 17 months for them to appreciate up to that $10,000 over appraised value. And so I wanted to make sure that you knew that this tool is available for you. So I know in our current environment, we do have a lot of clients that are asking what it's going to look like if they make a bid over appraised value or over sales price. We have this tool available. It can be co-branded along with some other flyers, which is we have the bid over ask, we have rent versus buy, and then our buying power. So if you have any questions about any of these co-branded marketing flyers, please feel free to reach out to one of your Prosperity Lending loan officers, and I'll hand it back over to you.
Thanks, Shelly. Appreciate you. Krish, question for you though. So on the appraisal waivers, you're saying that you're getting a lot of questions. Why are you getting so many questions?
Well, I believe that a lot of people are wanting to take advantage of, the market, obviously, and so wanting to avoid having to have an appraisal. We still require the appraisal if it's an FHA or VA loan. If our conventional loan actually fires off that automated approval that states that you do not need an appraisal, on purchases, we can actually avoid getting an appraisal.
That's amazing. That's happened on a couple of properties where I've represented buyers more than not.
Yes, every single one of yours actually.
Every single one of mine has gotten an appraisal waiver, which is great because they don't have to worry about the appraisal issue, especially in a market like this. But it's a little risky because they may have overpaid for their home. So lots of really interesting things in that. Now I'm going to pass the baton on so that you guys can see what Miss Janet Carpenter is wearing from Chico's today. Janet Carpenter.
Good morning. So I'm just going to bring you up to date on a couple of things. First thing is an issue that I talked about last week, but there's still a whole lot of posts on Facebook about why are the realtors left out? And this is about the COVID-19 vaccines. You have not been left out. You are eligible to get a vaccine if you want it. Now I put this we talked about it last week. It was in the newsletter last week. And I had an agent who went online over the weekend. And by George, she got her first vaccine on Monday. They are available for realtors. Now some people have said, they ask for your real estate license, but everybody that I personally talked to that's received the shot from the Southern Nevada Health District said they didn't ask for anything. But you are considered a frontline essential worker with the business that you do. So you can go on the Southern Nevada Health Division website and make your appointment. I talked to a group of people who went Monday morning to Canyon Springs High School, and they said it was like a well-oiled machine. The longest wait they had was the 15 minutes they had to wait after the vaccine. And I will tell you my personal story. I went on the Walgreens app. You have to download the app and register on there. And I had an appointment for my final shot at 9:15. I'm there early. I check in. There's nobody else there. I sit down in a chair, and before I could even get my phone out of my purse, they called me, took me to a little room, gave me the vaccine, and said, you must sit and wait for 15 minutes. No one else has shown up. I wait 15 minutes, and I have this thing about drugstores. I like to go up and down and peruse the aisles and see what I can't live without. No one ever came in to get a vaccine. So you might try your neighborhood Walgreens. It was 3 minutes from my house. So bottom line, if you want it, you can get it. So the next thing I want to talk about is this Thursday in Summerlin, live, starting at 11 o'clock. If you need a new photo for your business cards, we are having photos starting at 11 o'clock, scheduled every 15 minutes, thanks to Prosperity Lending. It's free to you. And you just have to RSVP to Bobby at my front desk to book your appointment time, and they will run until we have no appointments left. We're also having a new agent orientation. Now, there are a lot of you who have joined us in the past year, and when we shut down in March, we quit doing orientations. So a lot of you do need it. If you show up at 12:30 at Summerlin, well, show up with an RSVP. You'll get lunch, and then at 1 o'clock we'll start the orientation. So if you need it, please, live in person Thursday at Summerlin. So, and the lunch is also sponsored by Prosperity Lending. So, and I also want you to know, a lot of buzz about Brandon's Signature Real Estate Academy. It is full. So if you missed out, hopefully he'll do it again. He has been doing it once a quarter. The other thing I want to talk about, we've talked and talked and talked and talked, your whole leadership team, about RPAC, Realtor Political Action Committee. If you've worked it all this year, or 2020, if you made a dime, it's because due to our lobbying efforts, the governor considered realtors essential. So if you made a dime, you need to give back at least 2 or 3 cents to RPAC. So to raise money, RPAC is sponsoring a fundraiser called Whiskeys of the World. It's going to be a virtual event from this whiskey person in San Francisco, but it's $200, and you will get like 6 different kinds of whiskey sent to you with a glass. He's going to explain each whiskey, what to taste, what to smell, whatever. And so we're going to do this live at the Southwest office on March 25th. It starts at 6 o'clock, and it's $200, and that will be a $200 contribution in your name to RPAC. So essentially you're getting a whiskey for free. We're going to start here. Prosperity Lending is going to provide snacks, because we will be drinking and having adult beverages. Now here's the thing, the packages with your whiskeys in your glass are going to be sent to Las Vegas Realtors, and they should be there on the 18th of March. To make it easy for you, I'm going to put the link where you go in and pay your $200 in the newsletter. I'm also going to post it on Facebook. But to make it easy for you, if you pay and get your receipt, if you email me your receipt, I will go pick up your whiskey for you, so you and bring it to the Southwest office. I'm doing it for Southwest and Summerlin, and Lisa Cobb is going to do it for Green Valley. This is a company-wide function. So please pay your fair share of $200 and join us in whiskey tasting on March 25th. Thank you.
Very cool. Thanks so much, Janet. So it sounds like we've got photo and food with Janet this week, and then we've got booze and food with Janet next week. Okay, so but just to clarify on the whiskey thing, you don't have to do it in the Southwest office. You can do it at home through the Zoom link if you'd really like to. What we are doing is providing you an opportunity to be in office with some of your friends, your real estate family, however you'd like, you are welcome to join. But please, please, please make sure that you are contributing and investing in RPAC in some way. And this is just one of those innovative ways that we're looking to expand our reach to our realtor members. So thanks so much, Janet. And really all I heard from her was read your damn newsletter. I think that was the gist of Janet's little segment there. Now, who's this handsome little married guy next to me? Sorry, I didn't mean to do that. Who's this handsome married guy? Yep, Mr. Sanders is off the market, you guys. He is officially married as of this weekend, so yes, congratulations, David. And it sounds like it was a lot of fun. You sent me some videos, and it was beautiful out there.
We eloped to Carmel by the Sea in Northern California.
Fantastic. That was because you did say you were going out of town last week, and you never mentioned that it was to get married.
We decided to make everyone angry with us. My mother literally found out on social media.
So here's the thing. My rule about eloping is that as long as you're doing it, it's just the two of you, it's cool. But you invite one other person, a friend or anybody else, now you're screwed. Now you got to get everybody else involved, right?
Well,
so I think you did it the right way.
We plan to have a huge party at the end of the year. Once we're allowed to have events with more than like 20 people. So
cool.
That's the plan.
Cool. I think I'm on that list, on that guest list, right?
Yes.
Yeah, not to put you under pressure, but we're live. You all heard it here. So I wanted, before I really get into the gist of what you and I are going to talk about, I did want to give a legislative update because I think it also, one, we do legislative updates every 2 years, and two, I think it really is going to chime in with what we're going to be talking about today, right? So the legislative update, there's been, like last week, I had actually posted something on the Agents of Signature page, and during regarding 141 that's coming out. It's a new bill that just came out it's gone through the Judiciary Committee, and I did a video on it. I put it on Agents of Signature. It's on my Facebook, on my Instagram. I recommend that you review it, but please do me a favor and oppose 141 if you can. The link to how you can do that is actually with the video. I will post it again in Janet's newsletter, so read your damn newsletter. It will be in there as well. I think it's really important that our legislatures hear from us about why this bill is such a problem. And so one of the things that it does, which is not really, in my opinion, not the worst of the worst, but it still does cause, I think, delays for getting tenants out who necessarily haven't paid in 6 months, a year, 3 months, whatever, it doesn't matter. But extended periods of time for notification for actual notices to have them not necessarily evicted, but notices for removal, right? And we're going to talk about the difference between eviction and 30-day notices. And then the thing that I find the most problematic, and it's because I just recently had an incident that drives me bananas, but the reason I'm really opposed to this little segment within the bill is that it says evictions will be sealed if you are affected by COVID. Now, listen, I get it. People have been affected by COVID and they have lost their jobs or they're no longer working and they can't make their rent payments. Understood, right? For people like that, it's great. But the people who are taking advantage of the system, there's no differentiation between the two of them, right? And I think that's the problem, is that if we as property managers or landlords were allowed to ask for proof or, provide us proof that you have actually been affected by COVID, provide me your last 6 months of bank statements, right? So that we can show to the court that that was a thing. I mean, ideally, most tenants just have to submit a declaration and that's it. But the burden of proof of that declaration lies on who? The property managers and the landlord. I don't think that's fair.
There's certainly in the last two sessions, there's been some... Yeah. There's a pattern here.
Well, they hate landlords, really. I think that's what the issue is. And quite honestly, there are people who can't afford to buy homes. So if you can't afford to buy homes, what's your option? Rent a property. And if you can't rent any properties because there's none available, what are you going to do? Move out of Vegas, right? If we don't have any rental properties, what are we going to do? Great, thanks. I appreciate the update. So there's that. So do me a favor, oppose 141. The link will be in your newsletter. It's also in Agents of Signature, and I will put it on for today's meeting as well so that you have it in the comments section, and it's easy to find. Now let's talk a little bit about, are you ready?
I am ready.
Okay, what are we talking about?
Talking about lots of different things.
I know. Personal branding. Let's talk about that really
Okay.
quickly because this has come up quite a bit in the last few weeks for me. I've got agents that have asked, hey, I'm doing a logo, and I said, what's the purpose of the logo? Are you starting a team? Is it for personal branding? Is it what? And it seems like a lot of agents are personally branding, which is phenomenal. I think it's great that you wanna stand out in some way, and you have a logo, for instance, to do that. However, there's still legal requirements for that.
Yes, so the real estate division looks at all advertisement essentially as mail-in advertisement. So they're going to require you to have the name of your brokerage in a prominent location. What prominent is, they don't define, but I would say it needs to be at least readily identifiable in your advertisement. You need to have your license number. You need to have your contact information. If you're a team, you have to comply with the team name obligations that the division has set forth. So there's nothing wrong per se with branding, but you make sure that whatever your brand is going to incorporate has all of those required, all that required information. Because if it doesn't, you're going to be potentially run afoul not only of NRS and NAC 645 and those fines, but it's also a potential violation of the Realtor Code of Ethics as well.
So in a discussion with the compliance officer at the real estate division, one of the things that him and I talked about was, hey, if there's a logo, right? If you have a logo, then the brokerage logo should be right next to it, right? And it should be in prominent. I mean, I know of instances where Janet has actually pulled out a ruler to measure the logos, against each other, which one's bigger than the other. Now, is that something that needs to be done? No, it needs to be prominent, right? I think it's great that Janet does that, and I think it's great, and you should probably also do something like that to make sure that you're in compliance, because really it takes one person to send out a notice about your violation, for instance, and now you are on the radar of the compliance officer at the real estate division, and everything you do, whether it's logo related or not, all your advertising is now going to be looked at again and again. So one violation is all it takes. Do me a favor, even if it's just the warning, make sure that you've got your logos and that the signature logo is prominent.
Think about the cost that you have. If you don't do this right the first time and you're spending all this money on a brand and then you're updating your website, you're doing business cards and you're doing signs and you're doing possibly even paid marketing, you get the ding from the division. Guess what that means? You have to stop all of that. You have to take all of it down, and you have to make sure that everything complies, or they're going to hit you over and over again, and the fines increase incrementally. So do yourself a favor. This is a scenario where you want to make sure that you default towards, the same size is a good thing. Making sure that your license number is easily identifiable in your logo, so that you don't run afoul of this. Because if you do spend tens of thousands of dollars, that's not an excuse. The division doesn't care. They're going to make you do it again.
Right. And ignorance is never an excuse for breaking the law, right? It's never
Not
been
in this case.
Not in any cases, actually, from what I understand. I'm not a lawyer, nor do I try to play one on this sales meeting, but I did do a year of law school. I remember that.
I didn't know. It doesn't sound like an excuse that's going to fly with Jan Holly, but maybe that's just me.
Yeah, no, it won't. So if you have your personal branding or your team logo, make sure that the brokerage logo is next to it. It needs to be prominent. If you're using just your team name or your personal name, then the name of the brokerage can be typed out as well. But when you're doing logo, it should be logo to logo. When you're doing name, it should be name to name. Make sense? If you have questions about that, talk to any one of the brokers. They're all listening to me and they know the rules now. The other thing is let's talk about FSBOs.
Okay.
Holy moly. So here's the thing. We're in a market right now where, I don't know, you could put a sign out in the front of your yard and boom, you've probably got 10, 15 offers. I mean, I have an agent that went to a house and there were 7 people literally waiting in line for appointments at that home. And it blows my mind right now. We have a shortage of inventory. We've reported it. I think I posted something on our Agents of Signature page and my Instagram saying we have 2.1 weeks of inventory, which is not a ton, right? So sellers are now just putting their homes on the market themselves and doing FSBOs. So we as real estate agents have to be more creative. And so what I'm seeing out there is that with FSBOs, we are, doing advertising on FSBOs, using pictures from the FSBO or open houses. Now, that was something that I thought, holy moly, is that in violation of clear cooperation, which is code of ethics, right? Is it a violation of, MLS rules and regs? And so we had a deep dive. I had a deep dive with David on it. What by deep dive, I mean like 10 minutes this morning. But we did definitely talk about it and what it looks like for agents to do FSBO advertising. Yes, it's an option, and to actually do open houses on FSBOs. So talk a little bit about that.
Okay, the lawyer in me, this makes me very, very nervous because the listing agreement, when we prepared it, it actually has language in there that says that any advertising activity conducted by the agent, you own the photographs. They authorize you to conduct that type of advertising, and more importantly, there is a waiver of liability in the listing agreement, meaning that if something is stolen during a listing, during a showing, or an open house, or someone slips and falls and breaks a leg, or the property is damaged, you are not responsible. You have none of that protection when you're doing a FSBO. There was an actual ethics case where, and it's a violation of Article 1 to misuse the access to the home that the seller has authorized. And we had a case where this was pre-pandemic, where a buyer's team, their business model was to ask listing agents from various brokerages if they could conduct open houses in the home. And they would advertise that, and the whole idea was, of course, to try to get buyer clients. Well, in this particular property in question, there were 2 homes for sale on the same address, or same street.
So 123 East Main Street and 124 East
Yeah.
Main Street.
They went to the wrong house. They set up an open house in the wrong house.
Shut up.
Yeah.
But-
They were lucky. The seller just told them, get out, and they did. They were lucky that the police were not called because they were trespassing. They did not have authorization to be there. So, in addition to the issues that you would have potentially with COVID, you have all of that you don't have that legal protection. So can you do FSBO advertising? Yes, you're going to need the seller's permission in writing and make sure that it's very clear that you are not an agent on their behalf, so there's no misunderstanding there. You're going to need permission to access the property or permission to use the photos. You'll need to, of course, comply with all of those advertising requirements we just said about personal branding for these on social media. It's not clear cooperation because it's not being put in the MLS because you not have the authority to list it. So there's no issues with MLS rules. But there is a significant amount of liability that is there just because, you would need their permission. And I would be very clear, time frames, who's going to be cleaning up the messes, who's going to be addressing all those kinds of things. If someone trips and breaks a leg, arguably the seller is going to be looking at you for the liability there. So you can do it. It's not something that you want to slap together at the last minute because the downsides are there. Do I think that in this market it's something that you could do to get creative? Absolutely. As long as you understand what a minefield isn't a problem if you know where the mines are. So as long as you're clear where you're taking your next step, you should be fine.
I'm slightly blown away by all the requirements, and so it sounds like you can't just get out there and start advertising. It sounds like you can't just get out there and start doing open houses on FSBOs. And let me be clear here, it is not the position of Signature Real Estate Group to have you go and or market and advertise FSBO listings for free. That's not the position here at all. That's not what I'm saying. In fact, if you can convert that FSBO into an actual listing, by all means do that. That's going to be your primary goal. But now with homes having, again, we have a shortage of inventory, is there a way for us to get creative? And I felt like this was an opportunity that we should talk about. And if for some reason the FSBOs, absolutely, I'm not going to do it, and you've worked them to death to try, but you have a buyer that might be interested in that, or you want to get some buyers who might be interested in that home, then there is a way to do it. But here's the thing. I would be really hesitant to allow agents from Signature to do any advertising on FSBOs or any open houses on FSBOs without having some form of liability waiver, right?
We could put together like a one-page liability waiver that would identify what they're allowing you to do for advertising, timeframes, so there's expectations, that the seller's going to keep the property in clean order, so you don't have to go in and clean it up for your open house. Those kinds of things. There's a lot of information we can put together on one page. In addition, if you do this, of course, you still have to comply with the COVID-19 requirements for showing property, and that's just a state expectation. You can't get around that. So that would also need to be addressed as well.
Okay, cool. So it sounds like we're going to be putting something together. You and I will work on that this week and maybe get something out by next week, you think?
That's fine.
All right. Surprise, Brandon, we're working on forms without your permission. So next, what happens when you get a notice of demand and you've closed escrow?
Okay, so this is a scenario where a buyer or a seller is unhappy. They've either retained an attorney or they've written the letter themselves, and they're saying, that they're owed something. Property wasn't disclosed. You sold the property for less than we thought we could make. Any one of those kinds of things. So the first thing that you do when you get a letter like that is you immediately go and talk to your broker, because there are things that the brokerage needs to do to make sure that it is protected.
I want you to repeat that.
Go to your broker. First thing, go to the broker. Because, for example, there is a standard kind of a letter that you get from an attorney that says, hey, we're potentially going to sue about this transaction, Signature Real Estate. We want you to keep all documents related to the transaction. That's a standard letter that lawyers send out saying, don't destroy, throw away anything. We may sue. Now, most lawyers don't know that you have a statutory obligation to retain this stuff, but it's a standard letter that lawyers send out all of the time. That doesn't mean that you're going to be sued. It doesn't mean Signature is going to be sued. It just means that, hey, there's some documents there. But if you get a letter and it's addressed to your client, care of you, because they don't have the client's contact information, first, of course, speak to the brokerage. They're going to probably talk to me about the best ways to protect everyone involved. And then you're going to be forwarding that on to the buyer or seller and recommending that they go speak to an attorney depending on the situation. Now, under this NRS 645 and the Code of Ethics, telling your client, we got this, we're willing to help you any way we can, but you really need to go to an attorney is probably your best bet. You have to be careful because when you get these demand letters after close of escrow, depending on how much you get involved, it could be interpreted as the unauthorized practice of law without a license, which is why we want you to go and speak to your broker so that they can talk to me. We can come up with and say, these are the things you can do. These are the things that the lawyer is going to send, and these are the things we need to tell the client. Because at the end of the day, if there's a dispute in the RPA between the buyer and the seller, it primarily is designed that we want that to be a dispute between them. You can help them all you want, but getting in there and negotiating, saying, hey, will you take $10,000 or these things were really disclosed and Mr. Lawyer, go away. You don't really want to be doing those kinds of things because that's not a real estate transaction. That is a breach of contract lawsuit. And unfortunately, it is intentionally designed to be a gray area. It is not you can do these 3 things, you can't do these 4 things. It's going to be highly fact-based, which is why we need you to speak to your broker. Because in one scenario, I could say you can do 1, 2, and 3. In another scenario, I could say you're not going to do anything and I'm going to handle it from here. So it really, I know you hate it depends, but this situation, the Nevada Supreme Court has come out and said it depends. So if you get a letter like that, immediately take it to your broker. Time is of the essence. If they say, please respond within 10 days, we need to take that seriously. It's not necessarily life or death, but, hey, so we got a demand letter 3 months ago. And here it is a problem because they may have just interpreted your silence as we're going to sue everybody. And that is not ideal.
Well, and some of these letters are just phishing, right? For us to potentially send it to our E&O insurance and insurance companies don't necessarily, if it's an easy fix, they'll just pay it out, unfortunately, and that sucks. And that's not the way that we want this to happen.
And I'll be honest with you, if I wasn't representing brokers, I'd send the letters to the brokers too, because we know you have insurance.
Sue everybody.
We know we have money. I mean,
sue everyone. Yeah.
That's what makes America great: the ability to sue everyone.
Fantastic.
So and that's why you have to take this stuff seriously, because potentially, depending on how the lawsuit is named, they may name you individually as an agent. They may just name Signature. They may name your client. You're going to have the fallout from the client saying, "What do I do? What can I say?" They've used to relying on you during the real estate transaction as having all the answers, and at this point, you don't. And if you
start giving them advice on what to do. Pay, they don't have a claim here, you can sue them, NRS 113 is totally protecting you. You've really got to be careful when you say stuff like that, because you are giving them legal advice. And if you give them incorrect advice, they then can sue you.
Well,
and that's a problem.
Also, if you give them legal advice, it is a violation of NRS, NAC, Code of Ethics. I mean, you're going to get the book thrown at you.
This is not one that you want to be the source. This is the scenario where you say you need to go speak to an attorney. Depending on the price point you're at, look, if you've got clients that are buying $1, $2, $3 million homes, they've got an attorney on retainer. That's not an issue.
Yeah.
It becomes slightly more problematic depending on at the lower price points when they're not used to working with attorneys. But there are services in Southern Nevada that can assist. If they're veterans, there are programs through Legal Aid of Southern Nevada for veterans. There are programs for the elderly through Southern Nevada Legal Aid. So there are resources that you can say, here's places that you can go and talk to. But I would be highly careful when you get these kinds of letters. This is not something that you can really sit on. You need to get a copy of it to a broker as soon as possible so that we can figure out the proper response.
Perfect. Thank you. You said all the right things. I appreciate it. Okay, let's talk about that DOJ decision, because we've talked about it every month since it started. If you don't mind doing a recap, we do have several new agents that have joined our brokerage, number one. Number two, just talk about sort of an update, even if there isn't one from the last time we spoke about it. Pretend like it's our first time.
Okay, so you might have heard that the Department of Justice had brought a lawsuit against the National Association of Realtors for several violations of federal antitrust law, primarily related to commission amounts in the multiple listing service. Now, antitrust cases are different from regular lawsuits. When the Department of Justice initiates an investigation for antitrust issues, they usually tell the person they're investigating and the party cooperates. So this could have been going on for a period of time under a confidentiality provision where they try to work out. And that's, we think, was what happened here, because when they filed the lawsuit, they also filed a settlement agreement where NAR said we're willing to do these certain things. And they, including some of them, for example, are the amount of commission that's being listed to the buyer is going to be sent out in the IDX feed, so it'll be available to the public. You should be able to nationwide search your MLS database by a commission amount. And there's a few other things that they've done as well. And so this came out in December, and antitrust law cases are different from regular lawsuits. They require a 60-day public opinion period. So after they submitted these documents to the court, anybody in the United States could give their 2 cents to the Department of Justice on this settlement. Now, if there were good things that came out of the public commentary, the Department of Justice and NAR could potentially add those to the settlement agreement. Once that 60 days has passed and the final version of the settlement documents have been prepared, then they have to submit it to the judge, who then approves them. Once those final rules are approved, then NAR is going to come out and say, here are the rules. They'll have to go to the NAR National MLS Committee for approval, and then be approved by the Board of Directors. So we're March. There hasn't been any updates as to those final documents since essentially the lawsuit was filed. So we know they're working on them. The final documents haven't come out as of yesterday with NAR's website.
So is it public comment time, or is
Public
it past
commentary has ended.
Oh, it's ended.
Yeah,
so
it's only
already
60
through it.
days
Okay.
from like December, so it's passed.
Okay, so now it's just a matter of, so I mean, what's the timeline for, getting
Well,
this?
so it's,
Another 90 days?
I can't imagine the federal government's going to want to wait another 90 days. So it really just depends on the finality, because the length, the thing that's going to take the longest is not the judge approving. That's probably going to be 30 to 60 days. That's pretty normal in courtrooms. It's going to take, how long it's going to take NAR to ramp up their process to have the MLS committee review, discuss, and approve, and then have the entire board of directors, and I know your signature brokers know that that's several hundred people. That's not That's not a small Zoom call. But the NAR mid-year events where they do have
That's coming up in May.
is coming up in May.
Right.
So they'll either, my guess is they'll either do an emergency vote next month because the government wants it, or they're going to do it in May. If it gets past May, I don't think the government's going to wait till November, which is the next scheduled meeting for those two committees, but they could probably schedule something quickly. Then once that's approved, then the local MLS and the Las Vegas Realtors will have to approve those rules as well. So we are unfortunately in the hurry up and wait time frame. You've seen some brokerages nationwide take advantage of this by saying, we're going to release the commission amounts that we have for our own listings on our own website, trying to spin this kind of thing. So it's interesting to see how people are attempting to market this before the rules become final.
Hey, I mean, you never know, anything could happen, right? There could be a last minute tweak, last minute changes. So, I mean,
the one thing that I'm really curious to see on the rules are, the commission amounts, that's a field in the MLS. That's just, it's going to be out there that we'll talk about ways to advertise and market with that down the road. The thing that I'm going to be really curious about is lockbox access.
Yeah.
Because they have indicated that lockbox access cannot be tagged to realtor membership. And so I'm very curious how local associations are going to deal with that scenario where they have to give access to anyone for the lockbox regardless of membership.
Interesting. I know that they're either going through lockbox decision making right now, or they're trying to figure something out, because I logged into LasVegasRealtor.com for something completely different. I was required to do a survey, and I couldn't get past it. Like, I couldn't be like, read later, and I just couldn't get past it. I had to make a bunch of things about the lockboxes, how many I have, and if I've had any issues with them. So I know they're probably thinking about this and preparing for it in some way, so it'll be interesting. But one of the things that we talked about before was the reason for buyer broker agreements, right? And how they're going to be way more important now than they ever have been because of this. And quite honestly, I recommend doing buyer broker agreements or doing buyer presentations to anybody that you're working with as a buyer. Even when you're in a listing appointment, they're going to go buy something, go do a buyer broker. Like, have them sign a buyer broker agreement as well. Duties owed and a buyer broker agreement. That should be part of your standard listing presentation if those clients are interested in buying something. And this will also negate any problems with the compensation, right? The co-op that's being offered. So what if it's advertised? Here's what I make. Here's what I charge, right?
And I think that's going to help you with that conversation, because if they're looking on, and then that commission amounts are going to be ported out to all the third-party portals. So if they're looking at a Zillow or a Realtor.com, the amount of commission that's being offered to the buyer's agent is going to be something that they can see while they're looking at property. And also on your individual websites as real estate licensees nationwide. So that amount of money that's being offered is going to be there so that you can have that conversation.
Yeah. Before I forget, actually, so we're almost, I know we're like already at 10 o'clock-ish, but we do have gifts to give away. It looks like we're going to have some gift cards. So because our attorney is here, we want to make sure that we're compliant. So there'll be 2 $25 gift cards that are being offered. So in order to play in the game, and Brandon's not here, so I don't know how we're going to win. But Brandon, I know that you're online, so hopefully you'll be able to help us here a little bit. Go ahead and text. I don't know. Married. Go ahead and yes. Do that specifically for Sanders. Thank you, Janet. We're going to text married to 725-527-7604. Again, that's 725-527-7604. Do I like married or do I like hitched better? All right, fine, married it is, because Beta's over there typing frantically to make sure that he gets it on here, and he's probably already put married. So married.
I get a finder's fee for these gift cards, correct?
No, that's not how that works. We're not allowed to pay attorneys anymore, right? So that's also a thing. Do you want to talk about that quickly? No. All right, perfect. All right, so let's talk about now, in preparation for this DOJ decision, right, whatever it may be, we've come out with a new form. And so talk about that.
So we have, in anticipation of not only this scenario, but addressing the fact that the commission, if you have got a buyer's brokerage agreement, and I like to joke that if you can convince a buyer client that your real estate experience is worth 95% of the purchase price as a commission, it's valid if you can find somebody who'd be willing to do that. So once you have that buyer brokerage agreement, you have whatever the amount is that you're paying, and then you have the properties that may offer less than that, there are a couple ways that you can address that. You do have to be careful of the Realtor Code of Ethics. So we have a form that's been prepared. And so what my recommendation is, if you are in that situation where the co-op that's listed in the MLS is less than whatever amount you feel you're entitled to or is in your buyer brokerage agreement, go speak to your broker before you start working on this form on your own. There are specific steps that we can take to make sure that you come in compliance with the Realtor Code of Ethics. And then also keep in mind that depending on the final rules that the Department of Justice and NAR come out, we may have to update this form just based on what is out there, but we know this is an issue, so there's a form that's available. It's a signature exclusive. So go and talk to your broker when you have this situation, and so they can walk you through the best ways to use this form, when's the appropriate way to address it. You know, if it's a FSBO, it's a completely different ballgame because you kind of have to address how they're going to pay you because it's not in the multiple listing service. So there's lots of different variations here. And so rather than having you fill out the form and inadvertently create larger problems for yourself, go speak to your broker. They'll walk you through how to do it. And I know you have some policies as to when to do that to make sure that you don't run afoul of the code. Again, it's not unlawful. There's the Realtor Code of Ethics just says that you can negotiate commission. You just have to be careful with the vehicle in which you use to negotiate that with the other side.
So we have a form for that. It looks like we've got two forms that we're talking about today. Obviously, the first one we still have to create. The second one is this commission form that we've put together at Signature. It is available through your brokers, and it's in regards to getting additional commission and compensation if there is an issue with what's being offered in the MLS. Now, I want to remind you that if you are, for instance, getting a FSBO, a commission from a FSBO, meaning you're representing the buyer side, you have to get something in writing from that seller saying that they're willing to pay you. Now, the form that we're talking about is more of like I want to say an amendment almost, or a counter or something like that. That, again, if you're interested in that or you have more questions about it, I recommend that you talk to your brokers about it. We are just finalizing some details on that form as far as boxes instead of lines and checks instead of so things like that, but that should be ready by the end of this week. So you'll have it available for, like I said, or like you said, a signature exclusive form that we have.
Yeah, and if you are working with FSBOs, you better have a buyer brokerage agreement as a backup, because FSBO, it's got to be written in somewhere that the seller's agreeing to pay you. And having that conversation with the buyer is very important because you're explaining the value that you bring, you're explaining the value of why properties are listed in the MLS, and you have to have those documents in place before you close with the FSBO, because you will not have contractual standing to bring an action against the FSBO if you have nothing in standard. So you've basically just done your work for free.
Now, there is a FSBO commission agreement in Transaction Desk that you can utilize if you so choose, right? And that's the one that I recommend that you do. So if you're representing a buyer who is purchasing a FSBO listing because you're creative like that and you went and found a FSBO that meets their needs, make sure that you call one of your brokers to help you if you don't know how to do it yourself. But there is a document in Transaction Desk to assist you. All right, now to the fun stuff. Let's talk about tenant issues.
That seems to imply that the rest of the things we have discussed have not been fun.
Well, so when I say fun stuff, I mean like the stuff that makes me, I don't know, sometimes my blood boils, sometimes just things that get me excited because I know a lot about it. So let's talk about tenants.
Okay.
And tenant issues and what happens if we're actually working with a buyer who is about to purchase a home where a tenant is occupied. Now, I know that in last week's meeting, there was in the broker roulette, how do you say it? Roulette. Broker roulette. They talked a little bit about this, but I wanted to make sure that we really dive deep in it. So first of all, there's a difference between providing a notice to vacate and an eviction. And so let's talk about that really quick. Okay.
So the notice to vacate is a requirement to start the process. Evictions are a little backwards versus like a regular lawsuit. So the first thing you have to do is you have to go and post notice to the tenant pursuant to the rental agreement and NRS 118A, which is the landlord-tenant statute. And there are different types of notice. There's the 7-day if they don't pay rent before COVID.
What happened to the 5-day?
The 5-day became a 7-day.
Okay, that was last legislative session,
Thanks to your
right?
friends at the Nevada legislature.
Okay.
And since pretty much all the justice courts are closed on Fridays. 7-day notice is generally about 2 calendar weeks.
And if you have a Monday holiday, right, you're looking at maybe longer. Okay.
So that's a 7-day notice. And then there's the 30-day notice is generally the no fault scenario. No cause.
Yeah.
You know, the landlords decide they want to sell the property, they're going to terminate the lease. We're giving you 30 days notice to get out.
Now, sometimes you can do that even when you're in contract and you've got 30 days left in the lease agreement, right? So 30 days prior to the lease agreement, you can do that, which is when most, and the reason we're talking about this is because we've got a lot of clients that are looking to sell their properties and they have tenants in place, or we have buyers that are looking to purchase properties and there's tenants in place. And so how do you, as the buyer's agent or the listing agent, handle that? And so there can be notices provided throughout the contract, right? Even if there's a lease agreement in place. I know last week they talked a little bit about how to maybe do what we called the cash for keys. I think there's another word for that. I know we've got all the brokers online listening in. So if you remember what that language is, It used to be called cash for keys back in the REO days. I don't know what it is now, but it's ultimately an offer for moving. Here's what we will pay you, tenant, for moving in 2 weeks.
To vacate.
And if you vacate a week earlier, here's what more we're willing to pay you. So there's options to get, entice tenants to leave.
Yeah, and there's nothing unlawful about any of that. If you are in a situation where you need to do that, again, speak to your broker. Make sure that you're doing the right thing. There's language that should be avoided in those types of things, and so you'll need to speak with your brokers if you're going to go through that. And so in that 30-day notice period, if the tenant vacates, there's no need for an eviction. They've left. There's nothing on their record. The landlord has the obligations under NRS 118A regarding final payment of deposits and accountings and all that fun stuff. But that's any property manager or landlord understands those obligations, so that's nothing unusual. If they don't leave is where it now becomes an eviction. So you've done the notice, then now you actually have to file something with the courthouse, an eviction. If you're going to do this, I highly recommend that you hire a eviction service that does this because it has to be accurate. The service has to be correct, or you're going to be doing it again and coming back again. So this is not something that you, even under state law, can serve yourself. You tell your clients you got to hire a service because it's required by state law, and you hire an eviction service, and there's several in the valley that do a great job. You could even potentially go to the constable's office, but they're incredibly backed up for a variety of reasons. So they have to do the notice of eviction and file it with the court. And then the tenant has a certain period of time to file something in response to the court, an answer. If they file an answer, you're going to get a hearing date down at the courthouse. They're primarily doing them through the court's website called Blue Jeans right now, but you can technically show up in person if you like. But if they don't respond...
I didn't get that. Could you try again?
Was that your Siri?
That was Siri being sarcastic. So if they don't respond, then you'll submit an order down to the court will sign it, and then you can proceed with a lockout. If they do sign it and do file an answer, there could potentially be some CDC guidelines. That's when they could file that document if that's out there. If you get any of that kind of stuff, you need to run to your broker, and we can talk about your best ways to move forward because there is going to be some wrinkles with that, assuming that the CDC guideline eviction moratorium continues on or ends. But there are certain exclusions to the CDC. Holdover tenants, which, if the lease is expired, is one of them. There are ways around that. So you want to make sure that you go speak to your broker about how to handle these things so that you're ready for the hearing. And depending on where you are, it's either going to be the Justice Court out at Henderson, which is pretty good. North Las Vegas has one judge that handles all of this.
I want to make sure that we're clear here too, though, because you as a licensee are not going down to the eviction court, right? You have to have a property management permit.
Yes.
You have to, or be the landlord.
Yes.
One of those two scenarios.
Or they can hire an attorney.
Or they hire an attorney, right? But you as a licensee without a property management permit are not showing up to eviction court because, one, your license doesn't allow it. You don't want to pretend like you're being a property manager because that's against the law and also against the code of ethics. So be very careful how you tread. I know a lot of us have clients who we love and want to keep as clients, and so we overstep sometimes to help them and go through the process of eviction. You cannot do that unless you have a property management permit. So contact one of the property managers. I'm happy to assist you. Brandon's happy to assist you. Carolina's happy to, I mean, we have tons of property managers here at Signature that can walk you through that process. But really remember that you as a licensee cannot get involved in a agreement between the landlord and the tenant, or between a landlord and a property manager at another company, or a lease agreement with a landlord or the property manager and a tenant. So be very careful on getting involved in contractual issues, because you could be in some serious hot water for that.
So if you're representing a buyer and the seller has the tenant and there's a property manager, that existing property manager should be the one who's taking point on all of this.
Correct.
On behalf of the seller. If you represent a seller who has a tenant and they're doing it themselves, then your advice is, contact some of these services. Most of those eviction services, you can pay a flat fee and have an attorney show up and argue on your behalf. There are several of them in town that do a great job with all of this. They're very familiar with the judge. The judges know them because they're there all the time. And that is the best way to handle it if you are not a property manager or familiar with. Even if you are a property manager and this is not something you're comfortable with, there's nothing wrong with recommending that they get an attorney, particularly with the steps and issues we have with the CDC guidelines.
And don't call David, he's way too busy. So, I'm kidding, but you are really busy. So here's the thing.
I actually, to be honest with the cost-wise, it's much better to hire the companies that specialize in it. My fees for doing it, just because of the way my business is structured, it's going to cost you more to have me do it than to have one of the companies that do it all the time have the process servers. And that's who I recommend. If people come to say we have an eviction, I usually just send them to one of these companies because they specialize in it, they know the drill, and it's just easier all the way around.
So I absolutely love Southern Nevada Evictions services. They're great. I was able to have tenants actually removed during an eviction moratorium. 2 tenants who weren't paying rents were removed. And so I utilized their services to help me through that process. And then also they had some information on so I don't want to get into the details of that, but just know that there are services out there that we can recommend to you if you're interested. Now, let's talk about, more importantly, the issue of if there's a tenant in place and you represent the buyer, and the buyer absolutely has to move into that property because, let's say they're FHA or VA or something, they have to be in that property within 30, 60 days. Shelly, I don't know the right answer. Can you give it to me? But they have to be in that property per their agreement with the bank for purchasing that home. Mm-hmm. And there's a tenant there. And there has to be some form of notification to say, hey, tenant, peace out, you got to go. Where does that responsibility or burden lie? Is it to the landlord? Is it to the buyer? Is it the buyer's agent? Like, who takes on that responsibility?
If it was me,
the answer is yes, or it depends.
It depends on the situation.
Don't say that.
It does, but what it depends on is if you're a buyer's agent and your client needs to be in there and there's a tenant, then you need to be extremely aggressive with the seller's agent that tenant needs to be removed. It needs to be evicted prior to the close of escrow. Period. So
we talked about this last week, and one of the ways to do that is to make sure that within the due diligence period or right after the due diligence period, there is some form of 30-day notice that's been provided, right, to the tenant, mm-hmm. and that there's proof of that submitted to the buyer.
Yes.
Right? And that can easily be done, by the way, if you hire an eviction services company, they can provide you that proof that, yes, in fact, they have served that tenant with a 30-day notice.
So, and then, those cash for keys discussions would be something that you would want to have the seller be doing or the buyer be willing to potentially, chip in for to resolve that. Because what you don't want to have happen is have the 30-day notice from the previous landlord overlap the close of escrow date.
Yeah.
Because if that occurs and the seller is no longer the owner of the property and no longer has the legal standing to bring an eviction, which means that 30-day notice is just wasted and you got to start all over again. So that then the buyer would have to hire an attorney and evict the tenant. And depending on how that goes, there could be consequences. I mean, if they have the CDC thing in place, this is not an ideal scenario for a buyer. It wasn't so bad pre-COVID. Now with COVID, if that tenant is in place and they've got a CDC declaration, which is something that as a buyer's agent you're going to probably want to be asking during due diligence. If they've got a CDC guideline in place and they cannot be evicted, you're not going to be able to get them out.
So with that though, I mean, a tenant can technically give that CDC declaration or Nevada declaration, because we've got one for Nevada as well. One's a little bit more strict than the other. Mm-hmm. But if they provide that, they can do it up until the very last day, right?
Yes.
They can do it on day 29 of their 30-day notice and you're stuck. Now there's a couple of things that I know with the courts. And for those of you who are interested in this stuff and are crazy like me and love watching and hearing about it, you can go on the Nevada Realtors website or on their YouTube channel, and there's tons of videos of how the eviction moratorium is being handled in courts right now. There's judges on there, the attorney general's on there, the treasurer has been on there. So there's tons of information on there that's up to date that you can listen to if you'd really like. But ideally, they can provide that notice, that declaration up until day 29. And if there's non-payment of rent prior to, which by the way, you should be getting those rent rolls during due diligence period, right?
You should be asking for payments history. Have they filed a CDC declaration? Have they filed the Nevada moratorium declaration? You're going to want a copy of the lease agreement. You're going to want to know when the lease expires, if it's a holdover, because all of those things are going to impact your ability to remove the tenants by eviction during that process. And so you're going to want to know that information. And if it's a gigantic mess and they can't provide you any of that information, that may be necessarily a red flag, because there's not really a way. You can't get them out for non-payment of rent right now. So,
okay.
But
that's an it depends kind of thing. Call me if you're trying to get someone out. We'll talk about some of their options.
Allow me to rephrase. You will not have access to the property on the close of escrow date.
Correct.
You will have to initiate some sort of legal action.
Correct.
That's going to delay that period potentially longer than 30 to 60 days.
Right. And so if a tenant doesn't move out, then you can go through that scenario, but you should just remember in the RPA it says that you're supposed to get lease agreements, rent rolls, and things like that. It already states that, right? It also says that rents will be prorated. So what it doesn't deal with? Security deposits. And it doesn't say, and I can't tell you how many times. So I've had agents refer clients who've just purchased home for property management to me, and as we go through the process, we find out that security deposit wasn't actually transferred during the closing or during the escrow, and now we're waiting. And yes, the landlord who was self-managing has an obligation to turn that back to the tenant or give it to the new property management company or the new owner of that property within 30 days. But sometimes they don't know the laws, right? And so it then becomes a burden on the property manager or the new seller, or the new owner, sorry. So it might be a good idea to ask for that security deposit transfer within the actual agreement. And I can help you with language for that. So it looks like we do have winners for the drawings, and we are at 10:27. We've got a couple more minutes. Any last minute thoughts that you want to talk about before I announce the winners who are apparently already announced? Thanks, Brandon.
If it's a self-managed property, I would immediately run to your broker and make sure that you're asking all this stuff in the RPA to avoid these scenarios. If it's a property manager, they've got a statutory obligation. You can always threaten ethics cases and division complaints and all that kind of fun stuff. But if they're a mom and pop,
it's only
landlord,
fun for you and I, by the way, right? Not everybody else likes that shit.
So
sorry.
If they're a mom and pop landlord, you may have some potential issues with one, even if that security deposit still exists, that they haven't spent it. There's lots of issues that could potentially arise in that, and you have to address those during the due diligence period. So if you have that scenario, I guess today's theme is, if you don't know what to do, ask your broker.
Thank you. So that's going to be today's sales meeting topic, is ask your broker. So congratulations, Linda Sanada and Tanya Jaim on the $25 gift cards. And with that, I think we're pretty much wrapped up and we've had last minute thoughts. Any questions that you have, you guys, ask your broker.
There was one question that says, aren't some of our GLVR fees due specifically for lockbox access? And the answer is yes, they are. How the DOJ
I was ending the meeting.
Is going to impact that is a good question.
We'll have that for the next time I come on.
No, talk about it now.
No,
We've
no.
got 1 minute, literally.
The answer is we don't know how it's going to impact. Yes, you're right. Until we get the final rules from the Department of Justice, it's a guessing game until the end of the day. So there's a lot of information that's going to come out in the next 45 to 60 days.
What if as a seller that is not moving furniture or personal things away at closing time? How did we not get these questions during the meeting?
I don't know.
What is that?
It was there.
Oh, okay. Christina, you know what? You can call me and we can talk about that because we are running out of time, but I will definitely address that with you. With that, you guys, thanks so much for joining us today for our sales meeting. And thank you, David, for being here and offering your insight on all things liability. And we look forward to having 2 new forms uploaded for you guys in the next couple of weeks. So look out for those. Talk to your brokers about them. If you have questions, don't forget, read your damn newsletter and ask your broker. Bye.